Hoy, en un giro dramático en el caso de Pablo Lyle, la defensa desató una tormenta de objeciones en la corte, pidiendo justicia con pruebas, dejando al jurado y al público al borde de sus asientos. Hello, llamitas encendidas con neón, soy Karol, dándole la bienvenida al canal donde le ponemos neón a la opinión, a todo lo que es trending topic en social media, familia, lo que está haciendo trending en la corte de Miami, sí, así como lo están escuchando. Si ustedes recordarán aquel triste caso, porque sí lo es, para todas las partes, porque todo el mundo perdió en esa situación, ese triste 31 de marzo del 2019, en esas soleadas calles de Miami, Florida, un incidente que cambió la vida de muchos y del más famoso, el actor mexicano Pablo Lyle. Si ustedes recordarán el altercado de tráfico que involucró a Pablo y al señor Juan Ricardo Hernández, un hombre cubano de 63 años. Durante el enfrentamiento, pues Pablo hizo una cosa que me aseguro, seguramente, que estará muy arrepentido. Pareciera, ¿verdad? Y eso provocó pues que el señor cayera al suelo y quedara inconsciente. 4 días después, pues ustedes ya saben el trágico final del señor Hernández, quien falleció debido a una lesión cerebral. Pues, ¿qué pasó después? Pablo enfrentó un proceso legal en Estados Unidos, fue arrestado, acusado de homicidio involuntario. Mientras esperaba su juicio, se le impuso arresto domiciliario en Miami. Y ahí, como en el 2022, finalmente llegó el día del juicio. ¿Y qué pasó ahí? Lo encontraron culpable de homicidio involuntario en octubre del 2022. En febrero de 2023, Pablo fue sentenciado a 5 años de prisión, seguidos de 8 años de libertad condicional. Este evento no solo afectó su libertad, sino también su carrera y vida personal, dejando una marca profunda en su trayectoria como actor y en su familia también, ya que ahora la que era su esposa ya no lo es. Ahora tiene hasta novio, familia. Y el resto de la familia del señor Hernández siguen llorando su pérdida hasta el día de hoy, buscando también por su parte justicia. Después de que lo declararon culpable, Pablo Lyle comenzó a cumplir su sentencia de 5 años de prisión en febrero. Sin embargo, su equipo legal no se dio por vencido. Creían que hubo errores significativos durante el juicio que justificaban una apelación. Su equipo legal en ese momento lo abandonó, ya no quiso seguir con él, y él tuvo que contratar otro equipo legal para que hicieran esa apelación. Su nuevo equipo de abogados presentó esta apelación argumentando que el juicio no había sido justo. Sostuvieron que la defensa fue severamente limitada por las numerosas objeciones sostenidas durante el juicio, impidiendo que presentaran sus argumentos de manera efectiva. Un punto central de la apelación fue que las instrucciones al jurado y la terminología usada por el médico forense, como el uso del término homicidio, influyeron negativamente en el juicio. Ahora, la defensa también alegó que no se le permitió argumentar que Pablo pudo haber pensado que el señor Hernández iba a buscar un arma, lo cual era crucial para su defensa de que actuó en defensa propia. Además, querían introducir evidencia de un altercado previo en el que el señor Hernández había estado involucrado para mostrar su posible agresividad, pero este fue también excluido durante el juicio original. ¿Qué pasó el día de hoy? Pues su nuevo abogado presentó una apelación oral, que es parte pues de este proceso. Ellos tuvieron la oportunidad de exponer estos argumentos que le acabo de mencionar ante un panel de jueces. Fueron 3 en total. Esa presentación ocurrió recientemente, como les digo, el día de hoy, y fue un momento crucial para el caso. Durante la presentación, los abogados de Pablo argumentaron enérgicamente que las restricciones impuestas durante el juicio inicial impidieron una defensa justa. La fiscalía, por su parte, defendió la sentencia original, argumentando que el juicio había sido justo y que las objeciones y limitaciones impuestas estaban dentro de los límites legales. El equipo de Pablo Lyle, sin embargo, confía en que los jueces de la apelación reconocieran o Sin embargo, confían en que los jueces de la apelación reconocerán las injusticias y ordenarán un nuevo juicio. Hasta el día de hoy, el panel de jueces está deliberando sobre esos argumentos presentados. La decisión podría tardar semanas o incluso meses. Mientras tanto, Pablo continúa cumpliendo su sentencia en prisión, esperando ansiosamente una decisión que podría cambiar todo el rumbo de su vida una vez más. El caso de Pablo Lyle sigue siendo un tema de gran interés público, con muchos pendientes de la resolución final. Su futuro, tanto personal como profesional, depende en una gran medida del resultado de esta apelación. Nosotros tenemos todo lo que ocurrió, lo que está pidiendo su abogado, la respuesta de los jueces a los argumentos, la respuesta de la fiscalía, ya que este es un caso en contra del estado de la Florida, Pablo Lyle versus el estado de la Florida, y por ende tiene que estar ahí el abogado del estado. También están sus argumentos. Aquí se los dejo para el que le interese escucharlo en su totalidad. No quiero editar nada ni omitir nada, porque también eso sería justo, no sería justo pues para este caso, para que ustedes también saquen su propia conclusión de cómo se irá desarrollando este caso y cuál sería la posibilidad de que a Pablo le den un nuevo juicio.
Let's get to that case. We'll call the next case Pablo Lyle against the state of Florida.
Mr. Chief Judge, and may it please the court, my name is David Marcus, and I represent Pablo Lyle. I'd like to reserve 5 minutes for the rebuttal, if I could. What happened in this case, in both the opening and especially in the closing argument, is unprecedented. The prosecution was able to shut down the defense closing with and basic...
Well, at risk of interrupting you.
That's okay, Judge.
I don't know that it's unprecedented because you've cited a case that seems to be on all fours, Blanks versus State, which the only distinguishing factor that I was able to see was that it appears that the trial judge admonished counsel to cease from making any further reference to improper conduct. Do you want to talk about that case and whether or not there were other cases that support what the second DCA did in that case?
Absolutely. Blanks is a great case for us, Your Honor, because in that case, there were only 6 objections. In our case, there were over 35 objections in opening and closing, 19.
Well, Mr. Marcus, in your brief and today, you've made multiple references to the opening, but I did not see any motion for mistrial or any other form of motion pertaining to the opening statement in the lower court record. Correct me if I overlooked that. No,
you're correct, Your Honor. The motion for mistrial was made after the closing, and that's why I want to focus on the closing argument today. And the Blanks case dealt with the closing. And so in that case, there were 6 objections, some of which were about impeaching the identification of the defendant, and according to Blanks, quote, significant subjects for the consideration of the jury in light of the legitimate argument on behalf of the defendant. And what happened in this case, Judge Miller, is so far beyond what happened in Blanks and another case from this court, a case called Jean. And that case is really important because in Jean there was only 1 objection. And in that objection, this court ruled it was improper, and there was a new trial granted because that objection went to what the defense was trying to present in terms of the defense in that case. And so what we see here are over 30 objections in closing that go to the heart of the defense. Let me start with the objections, and I'd like to just go through some of those categories of objections, if I could, from the closing. So the first category is speculation, those kinds of objections. And the prosecution made a critical argument throughout the trial and in its closing, saying that Mr. Hernandez, the victim, said, "Please don't hit me," shortly before he was struck. This is a pretty devastating statement in a self-defense case, of course. And so the defense wanted to respond in its closing and said that kind of statement was unlikely to have happened because Mr. Hernandez, the victim, was so angry that he came out of his car and started banging on the other door. And so there was an objection, speculation, that was sustained at page 2096. That's the kind of argument that we see in all of our trial courtrooms every day of the week. There were two other speculation objections that were sustained. One was when the defense lawyer tried to argue about how the jury should interpret the video. There was an objection sustained at page 2103 and 04. And the judge in that case said, ladies and gentlemen, don't rely on what the defense lawyer is telling you about how to interpret the video. Rely on your own interpretation. But that's what closing is for. Closing is...
Well, let's go back to Jean for a minute.
Yes.
Because in Jean, which came from this court, there was a reversal because the trial court precluded the defense attorney from arguing how to interpret a jury instruction and whether or not the defendant was in lawful custody. Are there specific jury instructions that were provided in this case that the objected to, in particular the sustained objections that were not sustained on a proper legal basis, that had to do with jury instructions that were provided?
Yes, Your Honor. So those objections dealt with the fear of the children, in other words, the defense of others. And so there were three objections related to defense of the children, defense of others, at pages 2093, 2094, and 2112. And those objections were based on relevance. And what the defense lawyer was talking about were how the children were reacting in the car. And why was that so important? I saw you wanted to ask something.
I would like you to make that argument for me as to why, clearly, defense of others is a viable defense. And assuming these children were screaming at the top of their lungs, both the defendant's children and the brother-in-law's child, how is that relevant to whether or not there was an objective, reasonable fear at the time of the blow in this case?
Yes, Your Honor. And this is so important. It goes to the heart of the defense. What the defense is able to argue throughout the trial and in closing with defense of others is the circumstances surrounding the blow. You don't take the blow in a vacuum.
No, but I'm saying, assuming that they're screaming their lungs off, how is that relevant?
It's
I want you to
relevant
explain it to me.
Yes, Your Honor. It's relevant to show what was going through Pablo Lyle's mind. What would an objective person in that situation with the kids screaming believe that he needs to do? He needs to defend those children. Imagine if somebody ran into this courtroom with a gun and the students all started screaming their heads off. That would be, you would be able to say the marshals reacted to the students. If the students were calm and they said, Marshal, we're okay. This guy, we know this guy. He's just a prankster from school. Don't worry about it, Marshal.
But in this instance, the decedent had left the car and gone back to his car when your client went from trying to get into the car to stop the vehicle to turning his attention to the now decedent.
Absolutely.
It's not that he was aggressive at the time of the incident. And we're required to look at this from an objective, reasonable person standard of whether there was any form of imminent threat at the time of the action.
That's what the jury's supposed to look at. What we're supposed to look at on appeal is, could the defense make reasonable arguments about that? And so exactly to that point, one of the arguments that the defense couldn't argue, it was an objection sustained, was he may have been going back to his car. The defendant, Pablo Lyle, may have thought he was going back to his car to get a gun, to get a knife, to go who knows what. This guy was so angry. The defense was not permitted to argue that in closing. And so that's really, really important. That was improper arguments sustained over and over again, starting at pages 2099, 2111, and basic arguments. Yes, Ron.
If I may, and I know we're interrupting you a
No,
lot.
no, I
and you're making
appreciate
key
it.
points. So what I see in this transcript a lot is objections are sustained, but then the evidence and the argument comes in somewhere else at the margins. So even regarding your last argument, I think the trial counsel for the defense said, in effect, kind of quoting the defendant, quote, "Of course, the full statement is, I had the kids in the back and I was scared," end quote. So didn't that kind of, in terms of the defense of children thing, and Judge Lobry raises the issue of its relevance, but it also kind of got into the record anyway.
So you're right, and the state does a good job of pointing out that some of these things do come in during the trial. The problem, Your Honor, is that the defense couldn't effectively argue those facts in closing. The defense lawyer got cut off from arguing those things, and that's why those cases that Judge Miller brought up, Jean and Blanks, reverse. Even though some of those facts got in during the trial, what this court and every court in Florida says is that the defense lawyer must be given wide latitude to argue those facts in closing, and they weren't permitted to do it. Sustained objections over and over, so the jury is basically told those arguments, do not pay attention to those arguments, and the judge in fact told the jury, that's for you, that's not for argument, that's not for you to consider. Over and over and over again. So yes, Your Honor, some of the facts came out in the trial, but the defense lawyer could not argue those facts as applied to the law in closing. 19 times objections were sustained. And
I just quoted from the closing.
Right, and then there was an objection sustained as to that point, Your Honor. On those arguments, there were objections sustained. So, I mean, yes, the defense lawyer admirably stood up there and tried over and over again to make the arguments, and he was not able to do it. I mean, Blanks talked about 6 objections. Jean talked about 1 sustained. There were 19 sustained here about arguments we see every single day in our trial courts. I see my time is up.
Your time is up, but do you want to address the issue of the medical examiner using the term homicide?
Sure, I'll briefly talk about that one. Typically, Your Honor, we don't allow medical examiners to say that kind of thing in a trial because that's for the jury to decide.
I understand there are some cases that support the proposition that you've raised, but there are equally cases on the other side that stand for, and most notably, Spradley versus State, from the second DCA, which was authored by Justice Kennedy, where he says, in common parlance, homicide means the killing of a human being through human agency. The legal meaning of a homicide is no different, so there is no error in allowing, based on a proper predicate, the medical examiner to use that term. I don't know that this district has found differently.
And we're not asking for a per se rule in this case. The reason it was so problematic here is because of the closing argument. What the state did in closing is they said, they laid out the facts and then they said, don't forget the medical examiner also said Lyle committed homicide. So they emphasized that the medical examiner found this was a homicide. And that's, I think, the problem with what the state did here, over objection regarding that term.
All right, well, as a result, you would like us to do what?
So we're asking for a new trial here where the defense would be able to make a proper opening and closing, not be restricted, and where the state is not permitted to use the term homicide. And one other thing that we raise in our brief where we can get into the background and what happened that day with Mr. Hernandez, there's a case right on point from the second DCA, Bihana, that we talk about in our brief. So that's what we'd ask the court to do.
So we're going to grant extra time for this argument, so we're not cutting into your rebuttal.
Thank you, Your Honor.
On that last point, what exactly was the proffer? In other words, the evidence was excluded regarding the fact that the victim had a prior altercation earlier in the day.
Yes, Your Honor.
What exactly was the proffer regarding that prior altercation?
So he was at a supermarket in his new car. There was an incident where I think a shopping cart dented the car. He was furious about it.
From whom was this testimony going to come?
His wife, Your Honor.
And was she present at the time of this incident?
No, she wasn't. That's what he told her. And of course, the state's argued that that's hearsay. It's not hearsay. It goes to his state of mind.
How is his state of mind relevant to your client's state of mind and actions. Clearly, he was agitated at the time of the incident. He got out of his car. He went to the car in which your client was a passenger. But how is his state of mind relevant, and how does your client know anything about that?
So this is exactly what Bihana from the 2nd DCA 985 Southern 2nd 550 talks about. Quote, evidence of the victim's first violent encounter was relevant to show his state of mind, the victim's state of mind, and explain his aggression towards the defendant to show the context of events.
But how do we even know that it was a quote-unquote violent encounter? He was upset about a automobile dent earlier in the day. You're assuming that there's violent encounter, and how are we to know from what was proffered and from what you were capable of presenting to the trial court that there was any such violent encounter?
Sure. Violent is the way what happened in Bihana described it. We would have described what happened in the supermarket as context to show why he was so aggressive and banging on the door in his state of mind, and why that's inextricably intertwined with the context of events, which under that case is permitted, Your Honor. And so I'd say one last thing. I know I've gone way over about that case because it's really important. The state describes Mr. Hernandez, the victim that day, as just wanting to express his opinion, as nonviolent, as non-aggressive. The defense needed to be able to rebut that and said, no way. Let us tell you what really happened that day. This was not somebody just going to express his opinion. This was a man who was really upset. This is what happened earlier in the day, and that's what the 2nd DCA talks about, being able to give the context for what happened, and that's why it's so important.
All right, well, unless my colleagues have further questions, we've allowed you to go over 5 minutes, but thank you.
Thank you so much, Your Honor.
Please add 5 minutes to the state's argument. Ms. Ginsburg, any argument?
Yes, Your Honor. Good morning. May it please the court, counsel. The state's position is that Lyle was not deprived of his defense of presenting an effective closing argument. He received a fair trial, not a perfect trial, but a fair trial. He was able
to be, and I don't want to use Mr. Marcus's terminology, unprecedented, because we do have some cases that report on it, but the Supreme Court has said closing argument is the last clear chance to persuade the trier of fact that there may be reasonable doubt as to the defendant's guilt, and they've said that over and over again. It seems to me that the defense was severely curtailed for making routine arguments that are commonly made in criminal cases throughout the Gersten building every day. So it's hard for me to look at each objection in a vacuum, because it just seems to me that the overall tenor of the closing was that defense counsel was not going to be allowed to get to the next sentence.
Judge, to respond, there's no magic number of how many objections requires a reversal. The point is, how significant were they? What else transpired? What kind of instruction did the judge give? And ultimately, it comes down to, and it's been our position, that whatever errors occurred, and we conceded to a few, that they were harmless. And what we haven't heard Mr. Marcus discuss one iota are the multiple videos in this case that showed exactly what occurred, regardless of what witness testified, because the state's 3 witnesses didn't see the very beginning of the incident where Mr. Hernandez goes over to the car. Mrs. Araujo testified she didn't see what happened once Pablo got out of the car. All she could testify to was the kids were crying, she heard banging on the window, and she felt they were attacked.
This was really, when you watch the video, this was a perfect confluence of unanticipated events, right? We have the car rolling forward through the intersection, driverless. We have the beginning of the video, which is the decedent banging on the driver's side door and having a confrontation with the driver. Then the car starts going through the intersection. We know a little bit about what was going in the car. We know there were children in the car and they were screaming. How effectively that came into evidence, of course, is in dispute. So it's, and everything happens very quickly. So to suggest that the video is dispositive of this case doesn't account for the fact that different people view things differently. So closing argument has to be allowed, and liberality is afforded to the defense as long as they're not making improper arguments.
The state submits that the defense was allowed to make their arguments in closing. They made a justifiable homicide argument. They made an excusable homicide argument. They said that Mr. Hernandez battered Mr. Delfino. They argued that he was trying to get into the car and he caused a burglary. But what they never really address is the moments that came after that, where after, the car is rolling, Delfino sees it's rolling, so he jumps back in the car. Mr. Hernandez is just walking back to the car with his back turned, and, Mr. Lyle comes flying around from his side of the car, not walking, running. There's obviously words going back and forth, but he just punches him. And I don't see under any scenario with these facts and the defendant's statement, which was videotaped and in evidence. So
any objection could have been sustained and there would be harmless error because it was on video?
No, I'm saying the totality of the circumstances, the evidence that did come in. I believe they did make an effective closing argument as to each of their points. They were, some may have been improper, but in the entire context of the entire case, it was harmless error here. Let me see if I can respond to some of the things that Mr. Marcus argued or that you asked about.
Do you see the distinguishing fact from Baker to be the existence of the video or the admonishment by the trial judge or something different?
Which case?
Baker, the Baker case from the second DCA that has far fewer objections. I'm sorry, blanks, pardon me.
Blanks?
Yep.
Let's see, blanks. I think the main distinguishing factor, or one of the distinguishing factors, is that the judge rebuked counsel in front of the jury, and you can't get around that. They don't really go into detail about what the objections were, so I can't really respond because there's no facts as to what the nature of the objections were. So I think it's distinguishable, at least by the fact that the judge here did not admonish counsel during closing. She just simply encouraged the jury that, you determine what the evidence is. You're going to make the reasonable inferences from what you see. And so it's distinguishable from blanks. Jean is also distinguishable because in that case, it was an escape charge and the defendant wanted to argue one of the elements wasn't proven, that he wasn't in lawful custody, and that was shut down. We don't have that here.
We don't have an admonishment that I am aware of in front of the jury, but the repeated sustaining of objections certainly sends a message to the jury, given the fact that there's a standard jury instruction in criminal court, that if an objection is sustained, you should not speculate on what might have occurred. So they know that there is something associated with a sustained objection that's improper. So doesn't the repeated sustaining of objections that may not stem from an improper argument, that the argument is not worthy of digesting?
Respectfully, I would disagree, and Mr. Marcus only points out the objections that were sustained. There were a lot of objections that were overruled, and then in rebuttal, defense counsel did the same, got revenge on the prosecutor and objected 39 times, so he couldn't get a word out.
So there were a line of objections, as Mr. Marcus mentioned, that the victim was so angry, the defense counsel speaking to the jury, hey, the victim is so angry, sure he's walking back to his car when the attack occurs, but maybe he was going back to get a gun. What would a reasonable man think of when they're dealing with someone that angry as this victim was? object, speculation sustained. Was that a proper objection? And if
I think
not,
in this
did
instance, it was a proper objection because here we have no evidence of any threats by Mr. Hernandez.
Well, he banged on the car window.
Okay, but
He
has.
jumped out of his car, ran up to another
He
car,
was-
in traffic, banged on a car window.
He was hot-headed and upset, and he did do that. But that's not the end of the story. They're saying this never would have happened if he never got out of the car. We're saying if Mr. Lyle got back in the car, this never would have happened once the car was stopped, and they could leave and go to the airport and go home.
But I mean, is that improper argument saying the defendant was confronted with a situation where he's dealing with the defendant's version, someone who's angry, is going back to his car? So can the defense counsel then argue, hey, look, why was he going back to his car? Was he going to go to church, or was he going to get a gun? I mean, is that speculation at that point?
Our position, it is speculation. If there was a threat, this isn't over, I'm going to get my gun, I'm going to get a bat. If the victim had any kind of weapon on him when he approached, then that would be reasonable. But under the legal test that the jury had to decide, applying the facts as they were, it wasn't a reasonable belief that he was.
Well, let's say it was
that the
a
defendant
traffic-
was in imminent harm.
Let's say it was a traffic stop, and a police officer pulled over somebody who was very irate at being pulled over. The police officer goes back to their patrol vehicle to run their identification, and they see them reaching into the vehicle. We hear all the time they thought they were reaching for a firearm. Why is this argument any different than that? When you have an extremely heavily agitated person who gets out of their car in traffic, approaches the vehicle, starts banging on the driver's side vehicle, and then the car lurches forward, driverless, into traffic. I mean, how is that not an argument that can be made under the facts and circumstances of the case?
What, that he was reaching
What
for a
would be
gun?
the improper nature of that argument?
The state's position is that it's speculation that he was going to get a gun. And the alternative is
But don't we deal with speculation issues a lot in the context of self-defense? Because people are necessarily drawing inferences from a factual scenario, and they're making life and death decisions that are not always perfect. I mean, we see this all the time, routinely. So they're charged with gathering factual circumstances and trying to predict how somebody they don't know is going to react.
The jurors here, they live in Miami, they know about road rage. Even without counsel saying it, they could be thinking it themselves that, oh, he might have been going back to get a weapon. But, under the evidence, they viewed it, they applied the law to the facts. In fact, the only thing that they asked about during deliberations was for an extra copy of the jury instructions so that they could understand exactly what they were. I mean, there was even an instruction that the jurors could presume the defendant was in fear if certain things occurred. And then they asked for the video of the incident. And then they quickly came back after reviewing the instructions and the video and their discussions, and they reached a verdict.
How about the exclusion of the testimony regarding the children's fear? In other words,
It all came in. What the exclusion was...
I guess it's exclusion of evidence and exclusion of argument to some extent.
The judge's ruling was that Anna could not testify as to...
You mean the defendant's wife?
Yeah, yes, respectfully.
It was in the back seat of the car.
Right, that she
with the
could...
kids. So I just want to make sure.
Yes, that she couldn't testify as to how Pablo felt or thought. Anything she observed and saw, she could testify to. So it all came in. The kids were crying, the banging on the window. We were so scared, we felt attacked. The defendant also said, I did it to protect my family. I mean, what else could they have brought in? honestly, I don't know what other testimony they could have allowed in than what did come in.
You want to address the medical examiner's use of the term homicide?
Sure. Well, on cross-examination, defense counsel made it very clear that that the medical examiner was not considering justifiable or excusable homicide as a defense. He said specifically that's for the jury and the court and the lawyers to decide. I just telling you, you know, the punch caused his death. And talking about non-deadly force. So I don't see any error in this case. It's certainly unlike the cases cited by appellant where there was no predicate for the medical examiner to testify as to what he did testify to in the causation. Because if we didn't, you know, there was a question, was it deadly force or non-deadly force? And he had to explain the whole sequence of events. And as I stated, the defense made it very clear. I don't believe the prosecutor argued that in closing. The initial closing was all about the elements of the crime and applying the facts to the elements of the crime, that it wasn't justifiable, wasn't excusable. And I don't recall that being argued in the rebuttal by the state at all. So I see it as a non-issue. And then I'll just touch on the inextricably intertwined evidence of the victim's fiance. As you indicated, there's really no clear proffer of what occurred. Even assuming what Mr. Marcus has represented, that the car got hit by a shopping cart and he was angry, it happened much earlier in the day, unlike the Bahana case that they rely on, which is 2 minutes before the defendant kills somebody, he's having an altercation with two people right in front of him.
Well, and the general rule is that in a self-defense case, that the defendant should make a showing that he's aware of the earlier incident, right? That
generally speaking, and obviously, how would Mr.
So the exception
Lyle
is narrowly carved out from there, right? Because it's a reasonable, objective state of mind based on all of the information that a defendant is armed with, right?
Who, the defendant's reasonable, objective state of mind?
Right,
Yeah.
right. So
Yeah,
if the
well,
defendant doesn't have notice of the earlier incident, it's
How could it
not
be
like a
relevant?
scenario where the defendant knows that there was an earlier altercation, so he's afraid that that earlier altercation is going to create a bigger situation than that exists.
Precisely. And I just think if you read the defense closing from start to finish, or you read all three, you'll see they were able to make very effective closing arguments as to each of their points. We submit any of the objections that were sustained that should have been overruled was harmless error in this case, and we ask you to affirm the judgment and sentence.
Thank you. Mr. Marcus, rebuttal.
Thank you, Your Honor. Thank you. May it please the court. Let me just address a few of the points that the state raised. The first one is this idea of harmless error. And so I think what I'm hearing from the state is that because there was a video played, the limitations on closing were harmless. But the video was not enough in this case. I want to make clear what happened in this trial. The state didn't just play the video and sit down.
Well, in the authorities that you're relying upon, the court found that they could not make a conclusion that, in light of the totality of the evidence, that the error was harmless. So harmless error is still something that's subject to our consideration.
No question. I have to show that the limitations on closing were not harmless. There's no question about that. I guess.
And in addition to the video of the incident, we have your client's statement to the police,
Right,
where he admitted the blow, and he testified, or he told the police that he was afraid for his family, and that was the precipitated his action.
Absolutely, Your Honor. The problem here that we're complaining about is not the evidence that came in regarding those points. It's the limitation about the argument on those points. So the same thing happened in Jean and Blanks. The evidence came in, but the reason those cases were reversed is because the defense lawyer could not effectively argue those points in closing. So here, regarding the defense of others, the statement comes in, and yet we can't argue it in closing. The video... yeah.
Mr. Marcus, I think the trial counsel for the defense below, as your friend has argued, was allowed to go so far as to say, look, Hernandez, the victim who was killed, when he was knocking on the window, he was committing a battery. He was actually committing a crime against, I guess, the driver. So that's pretty broad argument. In other words, the jury got to hear the defense's point of view.
Well, on some things, the jury did get to hear the defense's point of view, but not on many of the critical points. On the speculation point you just raised about with my friend about going back to the car, why, that whole argument was shut down, for instance. And so, so it's
a circular argument. There's a video, so it's harmless error. So you don't get to argue what's in the video because any curtailment of closing is harmless error.
Right on, Your Honor. So and what I heard from the state when they were arguing it is they were interpreting the video today. They were saying, you see Pablo Lyle the victim, Mr. Hernandez, just walking back to his car, and Pablo Lyle, quote, flying towards him. Even those kinds of words here in an appellate setting is a way of interpreting the video. When the defense tried to do that in the trial court with the jury, in closing, shut down. Absolutely shut down 19 times.
But there were also similar instances where Mr. Eisenstein made very effective arguments about the same points that you're talking about, where the court overruled objections as opposed to sustaining them.
There were 11 objections that were overruled, Your Honor. That's true. There were 19 in closing that were sustained. 19 valid arguments. You don't really see a defense by the state of these objections were proper. I mean, there was a half-hearted one up here, but the argument that maybe the jurors in their mind know that in Miami there could be a gun in the car, that's not enough. You have to be able to argue those things in closing. You have to be able to say, here's what's going through Mr. Lyle's mind. You have to be able to talk about the circumstances with the children's fear. When the state says this all came in, no, it didn't all come in. The arguments didn't come in. There were statements that didn't come in trial. For example, Mr. Lyle's statement, calm down, there's children in the car. The state admits that that statement should have come in. We can't look at each one of these individually. What I'm asking the court to do is to look at all of these globally in connection with each other, because I think when you do, it's pretty obvious. If there's ever a case where the defense was not able to make an effective closing argument, where they were shut down, if Jean and Blanks are to mean anything, this case is it. And there really needs to be an opinion explaining to the state attorneys down there, these young prosecutors, that this is not appropriate what they're doing to shut down a defense's argument. So I would ask that this case be reversed, that there be a new trial, that Mr. Lyle have the opportunity to actually present a defense, and that we just don't play a video and convict people and send people to prison for 5 years without an effective argument. Thank you so much.
Thank you very much. Counsel, thank you.